Well, I told you that he was a scholar and he's also a gentleman. And we appreciate your speech. Thank you so much. And it wouldn't be right if we didn't hear from our great mayor of the city of Rabat. We refer to Rabat as the capital of Morocco, very similar to Washington, D.C. This is where the action begins, in Rabat. And so we present to you the mayor of Rabat, and I believe he's going to share a few words. Fatala Oulalou.
بسم الله الرحمن الرحيم والصلاة والسلام على خير المرسلين السيد الوزير الأول السيد المدعي العام للمملكة السيدة الرئيسة Honorable delegates, ladies and gentlemen, good morning. It is my pleasure to thank you for your giving me the opportunity to take the floor before you as mayor of the city of Rabat, capital of Kingdom of Morocco, and on behalf of its members' council. I am also grateful to the National Bar Association for holding its midwinter session in Rabat. You are all welcome and thank you for your choice. Ladies and gentlemen, وأنا أرحب بكم في مدينة الرباط. أود أن أقول كلمة ولو قصيرة على عاصمة المملكة. إن مدينة الرباط مدينة قديمة، بدايتها بدأت بحضور الرومان في المغرب منذ 2000 سنة، وبعد ذلك بنيت في القرن ال11 وارتبط تاريخها بالأندلس بجنوب إسبانيا والبرتغال عدة قرون. ومنذ قرن بالضبط، أي في سنة 1912، أصبحت مدينة الرباط عاصمة المملكة المغربية مثل واشنطن كما قلتم السيدة الرئيسة. وعلى هذا الأساس سجلت من طرف اليونسكو في 2012 كتراث إنساني. وفي سنة فارطة، أي في سنة 2013، احتضنت مدينة الرباط المؤتمر الرابع العالمي لكل مدن العالم، وحضرت هنا بيننا العديد من ممثلي ومن عمداء مدن الولايات المتحدة. وفي 2010 وقع اختيار مدينة الرباط كمدينة خضراء بين 5 مدن في العالم، نظراً لأهمية الفضاءات الخضراء التي تملكها. إنها عاصمة المملكة سياسياً، ولكنها كذلك عاصمة المغرب الثقافية، لأنها تحتضن أهم المسارح والمتاحف، وتحتضن أهم تجمع غنائي وهو تجمع موازين. إنها عاصمة المعرفة، لأنها تحتضن أهم الجامعات وأهم المراكز البحث العلمي والمدارس الكبرى للتكوين والتعليم. وهي كذلك عاصمة البيئة، وهنا إلى حد كبير تشتبه إلى عاصمتكم واشنطن. السيدات والسادة، المغرب والولايات المتحدة لهم عدة نقط التقاء، فهما بلد التنوع البشري والثقافي. المغرب شبهه المرحوم جلالة الملك الحسن الثاني بالشجرة، جذورها إفريقية وأوراقها تصل إلى أوروبا، وتطل على البحر الأبيض المتوسط الذي يربطها بالشرق، وتطل على المحيط الأطلسي الذي يجعلها تطل كذلك على أمريكا في كليتها. المغرب والتنوع الحضاري، بلد مسلم وبلد أمازيغي وعربي وحساني، وله تأثير كذلك عبري. السيدات والسادة، بين المغرب والولايات المتحدة علاقات قوية وعلاقات صداقة، لأنه ما يجمعنا هي أولاً وقبل كل شيء قيم مشتركة، قيم الحرية والسلامة والديمقراطية والتسامح واحترام حقوق الإنسان. هي علاقات متجذرة في التاريخ، فنحن نعتز في المغرب كثيراً أمام أصدقائنا الأمريكيين عندما نقول لهم بأن المغرب كان أول بلد اعترف باستقلال الولايات المتحدة في سنة 1777، وعقد مع الولايات المتحدة في سنة 1784 اتفاقية سلام وصداقة. وأثناء الحرب العالمية الثانية في سنة 1943 نشير دائما ونبرز أهمية اللقاء التاريخي بين الرئيس روزفلت والمغفور له جلالة الملك محمد الخامس في أنفا في الدار البيضاء، وذلك في سنة 1943. وكما قال السيد الرئيس الأول، آخر لقاء تاريخي حصل بين قيادتي البلدين هي اللقاء الذي حدث في ديسمبر الماضي بين جلالة الملك محمد السادس والرئيس أوباما. العلاقات بين البلدين قوية كذلك من الناحية الاقتصادية، ففي سنة 2006 وقع المغرب والولايات المتحدة اتفاقية تجارية مهمة، وهي اتفاقية التبادل الحر. وفي سنة 1907 وقع البلدان على اتفاقية الميلينيوم تشالنج أكاونت التي تجعل الولايات المتحدة تساهم في محاربة الفقر في بلادنا ودفعه نحو التطور الاقتصادي. المغرب اليوم الذي تزورونه هو مغرب يتطور عبر الإصلاحات المؤسسية والإصلاحات الدستورية والإصلاحات المجتمعية والإصلاحات التي تهم حقوق الإنسان وتهم توسيع مجال المجتمع المدني وتهم حقوق النساء وتهم تحسن الحكامة. وضمن هذه الإصلاحات بطبيعة الحال إصلاح أساسي سيكون لكم أن تتعرفوا عليه خلال لقائكم، ويتعلق بمجال القضاء. Ladies and gentlemen, I wish you a successful meeting and a good stay in Rabat, which I convey you to manage to visit. I thank you for listening to me.
Thank you, Mr. Mayor. We appreciate your words, your kind words this morning. Thank you. We have some presentations for the mayor, but we're going to move forward with our opening today. And this is where we renew our pledge. And we're going to begin first with a brief history of the National Bar Association Judicial Council. I call upon my classmate from law school, the Honorable Terrence Keith, who is from Detroit, Michigan, and he's going to begin giving you our history. Judge Keith.
Alaikum salam. The rapid increase by the National Bar Association judges in cities around the country, a panel of judges was convened in Miami, Florida in January of 1971 to discuss organizing the plans. As a result, a planning committee was chosen to begin formal organization of a new council. The committee subsequently proposed a resolution for organization of the Judicial Council, which was adopted by the Executive Board of the National Bar Association on January the 8th, 1971. The resolution states that the Judicial Council shall be an independent, autonomous section of the National Bar Association with its own officers, bylaws, program, and treasury. Foremost among its objectives is the eradication of racial and class bias from every aspect of the judicial and law enforcement process.
And so many times, people wonder, why do we have a National Bar Association Judicial Council comprised of Black judges in America? So why did we organize? And to answer that question, I present to you the esteemed Justice Peggy Quince of the Supreme Court for the state of Florida.
Why did we organize? We organize as Blacks around our Blackness because the melting pot ideology has been ineffective in producing meaningful progress in our heterogeneous society. We have come to know that aspect for racial variations comes not through a disappearance of differences, but by the retention of a sense of racial distinctiveness. Consequently, we believe that each ethnic group fundamentally must learn to accept itself. And equality is not similarity, but acknowledgement of various differences. Further, we believe that this sociology of acceptance can be expressed in the law and developed by means of delivering more individual freedom. The right to be Black, therein established, will broaden the concept of justice and equality and can bring more freedom for Blacks and whites alike. Later that year, from August 3rd through 6th, 1971, Black judges from across the country assembled in Atlanta, Georgia, for the founding convention. Judge George Crockett, Jr. was elected chairperson, and the United States District Court of Appeal Judge William H. Hastie was the keynote speaker. The members of the Judicial Council of the National Bar Association believe that our system of justice will only survive and keep the confidence and support of all segments of society when those responsible for its trust continue to be the main catalyst for constructive change. Therefore, the Judicial Council will continue to review its terms of past performance and future potential. Our bench will always be prepared to define its values and accept its responsibilities to make meaningful progress toward the making of equal justice under law a reality for all.
We renew our pledge. Let us remove the blindfold from the eyes of American justice. Historically, it has obscured the unequal treatment accorded poor people and Black people under the law. We, the members of the National Bar Association Judicial Council, recommit ourselves to fighting for equal justice under the laws of the United States Constitution and the Bill of Rights, and thereby continue the legacy of our founders.
Brothers and sister jurists, when praises go up, blessings come down. Let us focus our minds and center our hearts as we pray today. Let us bow our heads. Almighty God, we the members of the Judicial Council of the National Bar Association come into your presence today with thanksgiving. Father, we just thank you for all your many blessings. We thank you for your traveling grace, and we thank you for your love. Thanksgiving for all you have done for us in the past. Thanksgiving for all you are doing for us at present. And thanksgiving for all you have promised to do for us in the future. We pray that you will grant us the courage to rededicate ourselves to the eradication of racism and classism from the judicial process, the power to rededicate ourselves to the improvement of public confidence in our courts, the strength to rededicate ourselves to fashioning effective remedies for legitimate grievances, and the will to improve the overall administration of justice in the court of this land. Finally, Lord, like your servant, King Solomon, our prayer is that you give us, thy servants, understanding hearts to rightly judge your people. This is our prayer, and we pray in the name of our Father. Amen.
And that was the Honorable Yvette Mansfield Alexander from Baton Rouge, Louisiana. Colleagues, once more, we are assembled to reflect on our past, review our achievements, set goals and objectives for the coming year, gain strength and inspiration through collegial association. Let us take this opportunity to rededicate ourselves to the mission of the Council by standing, raising our right hand, and reciting our oath of rededication. Please stand, all judges of the Judicial Council. I do solemnly pledge to uphold the Constitution of the United States and the bylaws of the Judicial Council. I will do my part to further the mission of the Council. I will remain informed. Be collegial. Do justice. And be temperate. Both on and off the bench. I shall be ever vigilant. And dedicated to our noble cause. until equal justice becomes a reality for all. Judge Trapp? You may be seated.
Justice is the constant and perpetual duty to render unto every person that which is due, not because of who he is, but because he is. Justice is not an abstract principle by the judge, but is based upon laws, the Constitution, and most importantly, what is just, equitable, and right. Any judgment which lacks justice and fairness is morally wrong. I light the torch of justice, the administration of which is the essence of our existence as justice. Judges.
We assemble with the realization that in unity there is strength, and that our society interprets formal organization as an index of a group's sense of urgency and concern. We come together aware of the fact that in knowledge there is strength, and consequently, we will concern ourselves with both the creation and application thereof. We organize to address ourselves to problems of long standing which have not proved positive action on the part of the general judiciary. But beyond all this, we organize to build a broader basis for judgment and an even larger vision of a just society. I light the torch of unity, the second principle upon which this council was formed. May we remember and always remain united. May we remain strong as well.
Collegiality, like college, is not solely a matter of civility and good manners. It fosters civilized debate and diversity in our world of ideals. Not just singularity and single-mindedness of judicial opinion and perspective. Collegiality allows us to be challenged by the course, even if we do not hone it in our pursuit of elimination and education, whether personal or professional. Collegiality leads us to one another in times of trouble and in times when we enroll and into the warmth of each other's light. Light that is so necessary to our continued strength, creativity, resiliency, intellectual capacity, and growth. Collegiality always allows us to shine our light. I light the final touch of our trilogy, collegiality. May the light of friendship shine throughout the Judicial Council and the world perspective, especially Morocco.
Let us stand and sing together. We have the lights, all of our members, and you may join with us. Judge Shauna Graves Robertson will lead us.
This little light of mine, I'm gonna let it shine. This little light of mine, I'm gonna let it shine. This little light of mine, I'm gonna let it shine. let it shine, let it shine, let it shine. Any more? Thank you.
That's Judge Shauna Graves Robertson from Salt Lake City, Utah. As the chair of the Judicial Council, I declare this midwinter meeting of the United States Judicial Council for the National Bar opened in due course for the transaction of all business as we begin the conference in Morocco. The big story, Morocco and Black America working together on judicial reform. And that completes our beginning dedication. I would ask the mayor of Rabat to please come forward. If you could join me on the stage. For your hospitality here in Rabat to the Judicial Council. And this is our gift to you.
Thank you. أنا سعيد طبعا بهذه الهدية اللي هي هدية أولا وقبل كل شيء موجهة إلى المدينة التي تستضيفكم. أريد كذلك أن أخبركم بأن مدينة الرباط ستكون سعيدة جدا باستقبالكم اليوم في المساء إن شاء الله في حفلة عشاء باسم المدينة ومنتخبيها. شكرا.
And I would ask that my partner, the Honorable Chief Justice of the Court of Cassation, please come forward. I would like to present to you, on behalf of the National Bar Judicial Council, and we sincerely appreciate our keynote speaker, the scholar of the Kingdom of Morocco, who shared with us his great words about the bond between Morocco and Black America, the big story. Doctor.
Abadi, thank you. Thank you very much.
Thank you. Thank you. Yes. You can say a few things.
Thank you for all this generosity, which was foreseen to be moral. Now it is also material. Thank you very much. Thank you. Thank you.
Thank you, Dr. Ahmad Abadi. Thank you. And this brings to a conclusion our opening celebration of this great historic occasion in which we have traveled so far to join with our Moroccan brothers and sisters, the great lawyers and judges, particularly the Chief Justice of the Court of Cassation. We sincerely appreciate the opportunity to begin this great conference, where we will have seminars, we will dwell in the rule of law, we will work on equality and the betterment of justice in both Morocco and America, because we will share our unique experience as Black Americans, as judges and lawyers in the great United States. We consider ourselves ambassadors on behalf of our country, and we welcome this historic opportunity, and we believe that it will be the first of many more to come. And we look forward to seeing you in America.
And here are materials for those of you who are present. Can you help pass these materials out? and they're copies of the Moroccan Code and copies of the American ABA Code of Judicial Conduct. What I would like to do, and Judge Houston and I have discussed this, and I've also talked with Justice Ayubi. Justice Ayubi is a member of the Court of Cassation, which is the highest court in the Kingdom of Morocco. Justice Ayubi was very instrumental in the formulation of the code and will speak to us this morning on the teachings of the code, how the code was formulated, and the structure of the Moroccan judiciary and how judges are selected in Morocco as an introduction to a discussion of Moroccan ethics. Judge Houston will be primarily responsible for a presentation, a comparative analysis between the Moroccan Code of Judicial Conduct and the American Code of Judicial Conduct. As a means of introduction, I'm going to call upon Judge Houston to discuss the evolution of ethical conduct in American jurisprudence, the evolution of the development of the Code of Judicial Conduct. Then I will call upon Justice Ayubi to discuss for us the teachings of the code, the Moroccan Code of Judicial Conduct, how it evolved, and how judges are selected under Moroccan law, and how the code is both taught and applied in Moroccan law. Okay? So let us begin our discussion with Judge Houston, who will again discuss the evolution of ethical conduct in U.S. jurisprudence and the evolution of the Code of Judicial Conduct. Judge Houston.
Bonjour. I consider it an honor and privilege to be in the company of the jurist of the great Kingdom of Morocco this morning, and also to work with one here on the platform during the course of our discussions here today. And it's always a pleasure to present to my esteemed colleagues from the Judicial Council of the National Bar Association. I wish to start this presentation here today with sharing with you the evolution of the judicial code and ethics as we know it. Where do they come from and why? We'll talk about both codes here today, as you know. The two codes we will discuss today are more than just rules drawn up by seasoned judges. The codes represent a combination of centuries of judicial and human experience and expectations of the public that are directly affected by the work that we do. As you know, the judiciary has no army within its control to enforce its judgments. The enforcer of the judiciary is the judiciary's power is the authority of moral authority. The continuing effectiveness of the judiciary relies on the confidence of the people to whom we serve in our resolution of the disputes. In America, we know this from the debate centered around the structuring of our Constitution in 1877. We also know it from the documents such as the Federalist Papers and the Constitution ratifying conventions in the various original states. John Marshall, one of the founders, stated that the judicial department comes home to every man's fireplace. It passes on his property, it passes on his liberty, it passes on his reputation, and it passes on his all. I would second the remarks of Justice Marshall, because in the performance of our duties, we hold in the balance the fortunes, the lives, and the very social fabric upon which all peoples in the world carry out their day-to-day lives. The notion of impartiality is the keystone to the system of justice. Many people have little contact with the court system around the world in their daily lives. So it is understandable that they feel overwhelmed and lost when confronted with an unfair justice system. Studies have shown that even first-grade children react negatively to a situation when their mother disciplines them without consulting any witnesses. So it is not a rare notion that the general public does not understand what we do, and their sense of fairness is what they see, what they hear about in other times. For the vast majority of the public, the appearance of justice is all that they have to go by. The public must perceive that justice has been done in a circumstance. So the administration of justice must at least appear to be disinterested and impartial, and it must in fact be disinterested and impartial. The perception of justice is simply boils down to this: judges should not have a dog in the fight. Stated differently, there should be an appearance in fact and an appearance in perception that disputes are resolved with detachment and impartiality. The notions of public perceptions and confidence in what we do was not the brainchild of the American experience. What I will share with you in the next few minutes is a historical walk with respect to how our code developed and why. I'd like to start with ancient Egypt and the concept of Maat, M-A-A-T or M-A-apostrophe-A-T. The Maat was originally personified as a goddess who guarded the gates of hell and heaven. Maat later became known as the Egyptian concept of truth, of balance, order, law, morality, and justice. According to some of the surviving literature, beginning with the Mosaic law of the first millennium, the Maat was a spirit in which justice was applied rather than the rule of law actually decided in a particular case. Maat was the norm and balance and the basic values that formed the backbone for the application of justice that had to be carried out in the spirit of truth and in the spirit of fairness. From the 5th dynasty, in the era of 2510 through 2370 BC, the king's designee was responsible for justice, and he was called the priest of Maat. The Egyptian experience, the ancient Egyptian experience, bears on the principles that we will discuss here today, dealing with the spirit of the law and the appearance of justice. In ancient Iraq, the Code of Hammurabi, the Babylonian law code, dates back to 1772 BC. It is one of the oldest deciphered writings of significant length in the world. The 6th Babylonian king, Hammurabi VI, enacted the code, and in that code there were 252 laws, but only one applied to the conduct of the judiciary. The provision in the Hammurabi Code read as thus: if a judge gave a verdict, rendered a decision, granted a written judgment, and afterwards altered his judgment, that judge shall be prosecuted for altering the judgment he gave and shall pay 12-fold the penalty laid down in the judgment. Further, he shall be publicly expelled from his judgment seat and shall not return nor take his seat with the judges at a trial. The Code of Hammurabi's experience, as we shall share here today in our discussion about the Code of Judicial Ethics, reflects on the principles of responsibility, accountability, judicial conduct, and sanction. In 529 scholars to develop a code of law for the Roman people. It became known as the Justinian Code. A provision in this code reads as this: even when the judge is appointed by the emperor, he is to set his heart upon all suits being conducted without any suspicion of unfairness. The party who thinks the judge is liable of suspicion of unfairness may reject him through the recourse before the proceedings begin. The Justinian principle here that's translated into what we have in our code is the principle of independence, integrity, and the appearance of impropriety. Centuries later, the barons of Old England wrested from King John the Magna Carta. A relevant provision in the Magna Carta reads, quote, "We will sell to no man, we will not deny or delay to any man justice or right." The Magna Carta is reflective of the principles we will discuss here today, dealing with integrity, equal treatment, and judicial conduct. There are also references to these concepts in the Quran, in the Torah, and also in the Bible. Our distinguished jurist from the great kingdom of Morocco will touch on some of the concepts applicable to the kingdom of Morocco. But you know, a discussion about judges, the art of judging, the impartiality of judges, cannot be had without mention of that age-old symbol of justice. That is the symbol of Lady Justice. She presents as a goddess equipped with at least three symbols of justice, and I'll just identify and work on those three for a moment. The sword, which symbolizes the court's coercive powers. The scales, which represent an objective standard by which competing claims are weighed. And the blindfold, which indicates that justice or the justice is or should be meted out objectively, without fear, without favor, and regardless of power, money, wealth, or identity. Lady Justice reflects concepts and principles that we will discuss today, dealing with integrity, independence, and impartiality. These are just illustrations that reflect historically the expectations of peoples all around the world of their judges and the roles that the judges perform. The same principles voiced in these ancient lessons also arise in our codes here today. I'd like to fast forward to the American experience. The Judicial Act of 1789 included, amongst this other text, an oath. Part and parcel to that oath is the following: I will administer justice without respect to persons and do equal right to the poor and to the rich. Those words ring strong with me, as I'm sure they do with you. Whenever I attend investitures of friends and others from time to time for two reasons. Number one, to celebrate the new judge coming onto the bench. But secondly, to remind me of that oath. I tremble and sometimes come to tears when I hear it, those words, and that I reflect on my human experience. I reflect on the African-American human experience when I hear those words. Because all we want in this world is truth and a sense of justice, as every other person throughout the entire world and throughout the entire human experience expects here on earth. Now, the first set of canons here in the United States arose after the 1919 World Series of all things. An interesting story. There are two versions. The first version is that 8 members of the Black Sox, well, in the World Series, the Black Sox were playing the White Sox in 1919. There was a scandal. It was called the Black Sox scandal. 8 members of the Black Sox team conspired with bookkeepers to throw the game, and they actually did that. And the Black Sox lost. Thereafter, this scheme was discovered, and the 8 members of the Black Sox went to trial on conspiracy charges. They were acquitted. They admitted, 4 or 5 of them admitted to the misconduct prior to the trial. Nonetheless, they were acquitted at trial. So this trial and the World Series event created a lack of confidence in the baseball games, and as well as within the judiciary. How could admitted co-conspirators be acquitted of their conduct? After the acquittal, a federal judge by the name of Landis was offered, and he accepted the position as commissioner of baseball here, there in the United States. His goal, his charter, was to cleanse baseball of the corruption so that sports fans would have confidence in the game to return to watch baseball so they could make money. The sports fans began to boycott games. They wouldn't pay their money to go to the games because they had no confidence that the best team would actually win. Judge Landis did that. But in the first year as baseball commissioner, he remained employed or chartered with being a federal judge. He was a federal judge and a baseball commissioner. The United States Congress did not like this circumstance. The Congress focused on the issue that how could a judge sit as commissioner when those cases may come before him in the future. This is in 1922, 1923. The American Bar Association was outraged. How could a sitting federal judge have the appearance of impropriety when he's also running one of the largest organizations here in the United States? So the ABA, in its frustration, went to Chief Justice Taft at the time. Justice Taft formed a commission and developed the first code of conduct for the American Bar Association. So in 1924, based upon Chief Justice Taft's efforts, the American Bar Association had its first code of conduct that addressed independence, integrity, impartiality amongst judges here in the United States. The Supreme Court weighed on conduct issues more and more right after the implementation of the code. The first case the United States Supreme Court dealt with was not a judge case. It was a mayor case. In that case, it was Toomey versus Ohio in 1927. In that case, the town mayor was also the justice of the peace. And he would actually hear cases and issue fines against wrongdoers. His charter, permitted him to keep the fines, the cost imposed as part of his salary. This case went to the United States Supreme Court. And for the first time, the United States Supreme Court addressed this issue of impropriety and judicial conduct. The Supreme Court stated that there was an appearance of impropriety that arose to the level of a denial of due process. The Supreme Court concluded that the appearance of impropriety was sufficiently suggestive of an impaired impartiality that mandated reversal of the case. That's just one example. There are many others. And this is, in sum, just a basic illustration of the development of the ABA Code and our focus, beginning in the 1920s in the United States, by realizing the lessons and listening to the voices of ancient civilizations as to why a judiciary with the awesome power that judicial officers have must be guided by a set of rules so that the public can have confidence in the outcome of cases, so that the public could have confidence in the administration of justice. Thank you very much.
Thank you, Judge Houston. Perhaps Judge Joe Mountain Landis should have remained on the federal bench rather than becoming commissioner of baseball. I'm a baseball buff, particularly the Negro Leagues, and he was one of the worst impediments to the advancement of blacks in entry into Major League Baseball. Just a tidbit of history out there. Next, we will hear from Justice Ayubi. Justice Ayubi will give us an overview of the structure of Moroccan law and his part in formulating the Code of Moroccan Conduct. English is not his primary language, he has told me, but he speaks it very well. That's not the language he speaks every day. I'm very comfortable in speaking with Justice Ayubi because the Moroccan judicial system is similar in structure to the French civil system, which is very similar in structure to the Louisiana civil code and the methodology of interpreting laws in Louisiana. So I feel a close brotherhood, Justice Ayubi, and very much empathize with how the Moroccan justice system is structured and implemented. So I give to you, Justice Ayubi, and listen, you may take all the time you wish in educating us. Thank you.
My colleagues and our American cousins, I'm very pleased and I'm very happy that you choose Rabat as a venue for your conference. This gives me an impression that you are coming back to visit your relatives in the continent, and gives me also an impression that all of us, you and the Moroccan judiciary, we are stepping the first step toward judiciary and justice without borders. So I was called while I was leaving the Court of Cassation for my retirement. I was asked by the Chief Justice to participate with you and prepare something about, I'm sorry not to be asked to prepare what Mr. the Chairman asked before, but I am here to talk about the ethics, the ethical standards, and the training for the members of the judiciary. And I will focus on the training of the judiciary, as I was, or I used to be, director of the judicial training and the judicial school. So I would like to talk about the Moroccan ethical charter before talking to the judicial ethics course in the school. But I can say that, please, as I told you that I used to be director of the judicial training, I can be a witness, and I can witness in front of you without swearing, that the course of judicial ethics came abreast of the charter, of the Judicial Ethics Charter, Moroccan Charter. They grew in the womb of the Super Institute for the Magistracy. The Super Institute for the Magistracy is the name of the school before they were born. And I would like also to come and to demonstrate with you the chronological phases and history of all how the charter was prepared and drafted, and also how the course, the draft of the judicial course was drafted. But as I am bound by the time limit, it's between I was told to do it between 5 and 10 minutes, I will jump over all the chronological and the early steps, or first steps, to come directly to the content of the judicial ethics course, which is now programmed in the school. And as I told you, I was asked to focus on the training. I will give you an idea about the content of the course, and also the methodology of how we used, and they are teaching now this course And by the way, it's a course for the basic training. It's for the new judges, for people who have never been judges. They will come directly from the law school to the judicial school. They will spend 2 years, and after 2 years, of course, at the end, they will pass an exam. If they succeed in this exam, they will be nominated as judges, of course, or as I explained to my colleagues, in the school, there is no difference between public prosecution or public prosecutors or the judges in the bench, on the bench. We prepare the same courses, the same lessons, the same training, and then when they succeed, they will be nominated as deputy of public prosecutors or as judges in the bench and several tribunals, district tribunals. So I start by, no, please go directly to the content, the achievement of the course. And before starting talking about the content of the course, I should mention something. I should mention that if we could realize this fruitful work of the charter and of the judicial course, ethical course in the institute, it's thanks to the close technical cooperation with the American Bar Association. I was participating in this. We worked on this project about 1 year with Justice Jackson from Canada, and we could have this course that I will present to you. So please, I will focus on the course. How many lessons? Can you please go further, go to the achievement of the course. The achievement of the course. Go. The achievement of the course, please. Okay, anyhow. This course, it's about 15 sessions of 2 hours each, comprising the following principles of the Charter. Yes. Judicial independence, integrity, impartiality and neutrality, equality, reserve and dignity, judicial competence, judicial conduct, and decorum. And also, in order to prepare the topics and the lessons, we set up some objectives for the trainers. Of course, if you set up some objectives for the trainers, to help them to prepare the topics or the lessons in the frame of these objectives. The first objective for the trainers is to teach judicial ethics in relation to the Charter of Judicial Ethics for Morocco. Of course, to distinguish between the Judicial Charter, Moroccan Charter, from the Canadian or American, but of course, that way we didn't teach and we didn't deliver the courses of ethical judicial ethics for about 5 years in the school. We were waiting for this Moroccan charter. So as we could have a Moroccan charter, we start delivering the course as it is now. The other objective is to develop a culture in the judiciary that actively fosters the prevention of ethical problems. And the last objective for the trainers is to deepen the trainees' knowledge on how to resolve ethical dilemma by furnishing the necessary tools for problems solving using, of course, with this, using the analytical framework. I will explain, I will demonstrate in front of you what is the analytical framework. And also, we set up, we made a set for the objectives for the trainees. It means that after the course, after delivering this course in 1 year, what will the trainees, the future judges, be able to do? The first objective is that the trainees or the future judges will be able to explain and analyze the ethical principles contained in the Moroccan Charter of Judicial Ethics. And also, they will be able to identify what constitutes an ethical dilemma and avoid situations that can lead to problems of ethical nature. They will be able also to develop the skills to resolve ethical dilemma that they may encounter as judges. The last objective is that they will be able to develop the attitude of an ethical judge. The training methodology of all this, how the professor of a trainer delivers the lesson of 2 hours. The 2 hours are divided. First, a discussion and exchange between the trainer and the trainees. It must take at least half an hour. Then a lecturate or a lecture. It must not go more than half an hour. And at the end, to illustrate, to clarify, to make it easy for a new judge who has never been a judge, who comes directly from the Faculty of Law, very young. You should give him a case study and help him to leave the situation. So the case studies are more important. They take the half of the lesson using the analytical framework. The analytical framework, I will, without you know it, but I will just demonstrate what is the analytical framework. In this analytical framework, it's 4 questions. We put 4 questions. It's like a guide to facilitate the way and how to find and to meet and to discover the resolution for the new judges. We put 4 questions, and while studying the case study, the events, the story, he should first answer this question. What's the ethical dilemma for a judge in these facts? If there is more than 1 question or dilemma, he should list them in order in which they should be considered. Then we move, if we list the dilemma, we should look for the reference. If it's a dilemma, why? It's based on what? Is it based on a code, the ethical code, on principles? Is it based on some established statute, code, conduct, court decisions that are relevant to resolution of the identified dilemma? Then, if it is, of course, after discussion between the trainees, between themselves, also reaction between the trainees and the trainer, we come to the 3rd question. In light of the events as they occurred in this fact situation, what are the permissible options, choices available to the judge? If there is a dilemma, how we could find an issue, an exit to resolve this? You should do this or you should not do it. You now consider that it is relevant to the code or principles, ethical principles or some decisions. What to do? And number 4, of course, we came to the last decision of the judge or the judges. After all these questions, if we answer them, then what's the result? Identify your preferred choice. If there are many choices, not only one choice, I do this as a judge, I cannot do it as a judge, but there are two options. I might do it, but in this way. I might do it, but in another way. Okay, I cannot do it. At the end, the judge should list and should take a decision, the final decision. Identify your preferred choice or option that, in your opinion, most closely accords with the rules, principles identified in paragraph 2 above. Then, in this frame of methodology, we move to a case study. I will just present a brief study or case study in order to demonstrate in front of you how we put this story of dilemma and how we give the trainees the opportunity to use this analytical framework to find a solution. Perhaps in this story, you are not familiar with some words or some technical or some names or some official names. I did my best to clarify and to make it easy for you. If you don't understand something, I will just, a judge has recently been appointed to a district tribunal. We don't call it district tribunal, but you, I think, have this kind of district tribunals. Anyhow, it is the primary court, the primary tribunal. He might be a new judge, a new president, or a judge newly moved from another tribunal. During his first working day, after hearing a case, the judge has been called by one of his colleagues to join them in their office. Apart from the judges, there was a visitor. I'm sorry to just say that he's a lawyer. It doesn't mean that always we have doubts against lawyers, but it's, you know, it's the principle of neutrality that I insist this. So this visitor was a lawyer, but a lawyer with how many titles? With 3 titles. I don't know that you can have this in the United States or not, but in Morocco, this visitor or this lawyer is multi-titles. The first one, he's a Senate. It means Chancellor in the second chamber. In Morocco, we have 2 chambers, like you, of the parliament. He's the second title. He is president of the departmental council. In the department, we have the council of the department. He is the president. Of course, he was elected. He belongs to some political parties or something. He was elected as president of that council. And this is more important. He is the owner of significant farms in the district. So now, the lawyer invites the judge to join his colleagues to a lunch reception held in his house. And this is very common in Morocco. When especially when a new appointed judge goes to a district or a small town, he is far from his family. There is no restaurants sometimes, and he is bound by his colleagues to go somewhere. He will find himself invited, or they will find themselves invited by a lawyer or someone. What to do? We will see if it's a dilemma or not. To join these colleagues to a lunch reception held in-house. He learns afterward that other guests will be part of the reception, some local notable persons as well as the governor of the department. So what we will do? Should we go and have this lunch or what? Okay, we start by, okay, please. Now we should start answering the first question in the analytical framework. What is the ethical dilemma for a judge. Is there a dilemma or not? After discussion, between, of course, the trainees, the trainer, they would come to this result. They would say the invitation comes from a lawyer, taking into consideration that he represents and defends parties in cases heard by this tribunal. Second, he represents the legislative institution. Third, he is the owner of significant farms in the district. So perhaps one of them or three of them might constitute the dilemma. Now we move to the other question. Why, if it is a dilemma, are there specific legal rules or established principles of ethical conduct that are relevant to resolution of this identified dilemma? Yes, after reading, after looking in the text or law, we go directly, and we want this. We wanted that the implementation of the charter, of the principles of the charter. Of course, they have copies from the charter. They go like when you go to a text in a code in a law, they say yes, in paragraph 1, 2, 4, 5, and 5 of the first principle in the Moroccan Charter with regards to the judiciary independence. There are some statements there, principles that you take a distance between the executive or something like that. And then paragraph 2 and 3 of the third principle in the Charter with regards to the impartiality. The last, or the third one, in light of we should answer also this question. In light of the events as they occurred in this fact situation, what are the permissible options, choices available for the judge or the judges in this case? Then we say yes, there is dilemma. Then yes, there is principles and in the Moroccan Charter that relevant to this. Then what to do? Of course, the answer might be like this: not accepting politely the invitation by apologizing to the lawyer, explaining that their presence might affect their impartiality and give to the public a bad impression on the judiciary independence. We move to the last choice, to the last question. If there are more options, what can you choose one of the most relevant answer or resolution to the issue? Identify your preferred choice or option that, in your opinion, must closely accord with the rules, principles identified in paragraph 2 above. Perhaps they say, it's not written, it's just a case study, empty, and these answers are not written in the case study. We keep and we leave the answer to every group. They can have another answer, but this is one of the answers. The last answer for the last question, they say, this is the only option remaining for the judges to be taken with respect to the two principles of the Charter mentioned above. Thank you for your attention, and I hope that I didn't make it very long to you.